Well, everyone, I hope you're able to log in to Microsoft Teams to join us for our very first webinar. We're super excited to do this. Again, we don't know how this program works to the best of our knowledge yet, so bear with us if there's any technological gaps here. Again, we will have this presentation video recorded, so this will go on YouTube, and if you or your friends miss this event, you'll be able to refer to it later, and we will send an email out with the link, and it will also be on our website, which is patelwealth.ca. So I'm going to tell, for those of you that are not our clients on this call, a little about myself. I'm Sheean Patel. I am the Associate Investment Advisor on the Patel Wealth Management team here at National Bank. And I'm a partner with my father, Sheean Patel, who's on the other side of the, somewhere else over there. And he's the one that founded this business. This business started in 1983? 81, sorry. And has gone from the stock brokerage business and has come into a full-blown wealth management business. So what I mean is we used to buy and sell shares for people, and that was it. Today, what we do is we don't just do investments, but we do planning, we do investing, we do financing, and we do insurance. So a little about, so the person we have on the call today is Susanne Greisbach. She actually joined us in 2016. And she used to work in Ottawa as a lawyer practicing wills, trusts, and estates law predominantly. So what I'm going to do is I'm going to pass it over to Susanne. She's going to tell us a little bit about herself. And then what we'll do is I'll start to ask some questions and she'll respond, and then Sheean will also respond, and we'll go from there. Okay, so over to you, Susanne.
So thank you very much for inviting me here today. I'm very excited to speak to your clients about estate planning. So as Sheean mentioned, I am an estate lawyer by background and by training. So I spent the first few years of my career working as an estate planning lawyer at a private law firm in Ottawa. I did primarily drafting of wills, powers of attorney, trusts, worked on incapacity planning, did some income tax and corporate planning as well. I also worked on the administration side. So after a client passed away, I would help their family members deal with the administration of the estate. So my role today at the bank since 2016 is to work with our clients to make sure that their estate plan is up to date, make sure that they understand it, and act as a bridge to kind of help those clients, connect with lawyers and accountants to make sure that their documents accurately reflect what their wishes and their intentions are.
Thanks, Susanne. The next going to scroll over to me, I think, in a second here. All right, so thanks, Susanne. Why don't we let Sheean just kind of introduce himself for a minute here, and then why don't we start on the webinar? So Sheean, over to you. Just give him a second to pan over. There you go.
Hi, everyone. It's good to be here today to introduce my team that's working diligently, as Sheean said, with wealth management and wealth planning. It's one of the important roles we have to have in our business today, and it's important to people to maintain their accumulated wealth for the betterment of themselves and their family. I've been in the business since 1981. I started as an investment advisor, commission-based, trading stocks, transitioned to wealth-based planning and discretionary portfolio management. All I can tell you is that this area is now very, very important to our lives. A lot of clients are asking about it today. And the most important thing is that we want to make sure that people's wealth is sustained through good markets and bad markets, especially in the last 3 months. We've had some severe market conditions, and it's good to know that our clients are not suffering. However, we want to do that for everybody. So I'm just going to transfer it over to Sheean and Susanne to go ahead and chit chat about estate planning and the importance of it and how it's going to help you and your family in the future. Thank you.
Thanks, Sheean. So I just want to put a little plug in here. If anyone wants to find out more after all of the questions are said, you can also you can get a hold of us by calling our number 905-849-3549, or you can also send an email to us or myself, sheean.patel@nbc.ca or sheek.patel@nbc.ca. And we will be able to take care of any questions that you do ask. Obviously, this is an educational event, so we won't be getting into the nitty-gritty for everyone, but we're going to go over the broad bases of estate planning. So I guess I'm going to roll myself into the first question here. Suzanne, why don't we just tell everyone what estate planning is?
Thanks, Sheean. So what I like to tell my clients is estate planning is really a process. So it's the process of organizing your financial and personal affairs so that your goals and wishes are taken care of in the event of your death or incapacity. So a lot of people think that estate planning is just having a will. And don't get me wrong, it's really important to have a will in place. That's the foundational document, but it's a lot more than that. Estate planning also deals with things like your incapacity, tax planning, probate planning, things of that nature. So, documents like your powers of attorney, having beneficiary designations, having life insurance, dealing with joint ownership and living wills. Those are just some examples of what is estate planning. So again, it's a lot broader than will, encompasses a large range of different types of documents and instruments.
Thanks, Suzanne. I think most people do think estate planning is just the will. That's funny enough that you said that. And she's absolutely correct. We've worked on many cases where it's not just that one piece. It's so much more, and it encompasses just a ton of things. So again, when we do have these conversations about this next time, everything's going to be tailored to you. This is going to be more of an educational thing. So why don't we jump into the next question here, Suzanne? Why do people need an estate plan?
Sure. So in very broad terms, an estate plan allows you to protect, control, and optimize. So in Ontario, we have basic laws that govern how assets are dealt with and how care is managed, but these laws leave a lot of room for flexibility. So for example, on the control and protection side for estate planning, let's say you have a beneficiary that has special needs. Estate planning allows you to put in place structures in your wills, allows you to have trusts in order to take care of that beneficiary. Maybe you have a child that has marital difficulty, or you have, let's say, a minor grandchild that you want to make sure that has some basic needs covered for them, or education, things along those lines. Estate planning, by incorporating the will, the trusts, insurance, beneficiary designations, all of that, allows you to have that peace of mind in order to protect your assets, control how they're distributed. On the optimization side, estate planning, part of what we do is we also look at your situation and determine how you might be able to save income taxes and probate fees, and also to help you create wealth for those that you leave behind. So things like dealing with, different types of trust structures, again, life insurance. There's a number of different ways that we can review your situation in order to not only protect and control what you have, but also to optimize your estate for savings and for wealth creation.
Thanks, Susan. Sheck, did you have anything to add to that, or did you?
No, I do. I was talking to a client yesterday, and basically, I asked the client some questions, and the importance is that they have to do it, but they have other issues they have to working with. I says you have to combine it together and get your will and estate organized, because he's a single mother, a disabled kid, and other children and grandchildren, has to have things put in paper. So if something happens, as Suzanne said, it protects and optimizes her assets to the family. It's so important that it goes that way. If not, Suzanne can tell us what happens if you don't have a will or anything in place. Who's the big beneficiary? I think the government, isn't it?
That's part of it, absolutely.
So that's basically what I wanted to put in. So, well, one of the questions I will ask Suzanne is, how often should you review your will and your trust documents?
Okay.
That's perfect. It goes right into the next question. Thanks for asking that, Sheck.
That's it. So The thing that's really important to understand, I've had a lot of clients who, they put their wills in place when they first got married, had their first kid, and then, they throw it in a drawer, and then 25 years later, they think that everything is still okay. It's just important to understand that estate planning, it's an ongoing process. So it changes according to what your personal circumstances are. So just going back to that example, that will you put in place when you first got married and had your first child, that might not be the estate plan that's the optimal situation for what you would have in place at retirement. So some things that might trigger you to review your estate plan in your personal situation would be things like the birth or the death of a family member, differing life events like marriage, separation, divorce. Those are all reasons why you would want to take a look at your estate plan and update. The other thing would be if your financial situation changes. So if you buy or you sell major assets, if you retire, major career shifts, those are all reasons to review your estate plan. In terms of another reason why you might want to make sure that you're reviewing regularly is that laws in Ontario and throughout the country, they can and do change over time. So a really good example of that is we didn't have assisted dying legislation until a few years ago. So estate plans that were put in place prior to that, maybe they're not up to date anymore. The way that we tax trusts, that has changed quite significantly since 2016. So documents you had in place in 2013 that were completely up to date as we knew it at the time, it might not be relevant anymore at this point in time. So we don't really expect clients to be keeping up to date on the minutiae of all the changes in the laws. So what we typically would say is that at a minimum, every 3 to 5 years, you should be doing a comprehensive review of your estate plan. Even if nothing in your family situation has changed or your financial circumstances. And it doesn't mean that your documents are going to have to be redrafted from scratch. Maybe nothing has changed, but it's just a good idea to check in and to verify during that period of time. And then obviously, as you get older, it's a good idea to bump that up a little bit to every year or every 2 years.
Thanks, Suzanne. I do want to let everyone know that there is a Q&A button beside the end call button. If you click on that, you can actually type in any questions that you have for us, and we will actually take care of them today. But yeah, let's. So thanks for. One of the things I wanted to add is that with Suzanne on our team and some of the clients that we've done the estate plans with, we've actually started to go over it for the first time after we initially did it only a couple of years ago. So this is an ongoing process with our clients, and we are also going to be there to tell you, hey, it's time to review your estate plan so that we can make sure everything's on track. As your financial advisors, we want to make sure that you're in perfect hands. So as part of creating the will and all this stuff, people always have to choose an executor. So how? I mean, most people will just say, okay, I'm going to get my brother to do it, or I'm going to get my sister to do it, or maybe even a good friend. What's the best way to find an executor for your estate?
Sure. So as you said, most people tend to default to immediate family members. And in some cases, that might be the best option, but it's a good idea to take a step back and think a little bit about what an executor actually does so that you can find the right person for the job. So in really broad terms, the executor is the individual or the company that steps into your shoes to administer your estate. So this involves everything from funeral arrangements, going through your house to deal with personal effects, paying taxes, going through the probate process, preparing and selling your house, making sure all your bills are paid, and then following what the instructions are in your will. So as you can imagine, acting as an executor, it's a pretty time-consuming task. It can also be pretty detail-oriented, can sometimes be tedious. I tell my clients, don't expect your estate to be wrapped up in any less time than about a year. Even for straightforward estates, it does take that much time. And what I've been finding is that estates are taking up to 18 months to 2 years, even in straightforward instances. The other thing to keep in mind is on top of all of that responsibility that the executor has, they may also be personally liable if they don't carry out their duties properly. So there's a lot involved in acting as an executor. So it really behooves you to give a little bit of thought as to who it is that you're putting in that role. So as you can imagine, you would want an executor who A, has the time, and B, has the skill. So you don't necessarily need someone who is, an accounting professional or anything along those lines, but you do want someone who is detail-oriented and organized at a minimum. The executor can always ask for help, so it doesn't mean they have to undertake every task personally, so they can definitely go to a lawyer or an accountant to get advice and to help them through the process. But it's important to understand that it's the executor who's ultimately responsible for whatever happens with the estate. So some other things that you would want to think about, you want to make sure that the executor lives in Canada. Reason being that you don't want to start entangling other countries' tax laws, because that can get very complicated. You don't want to pick someone who's significantly older than you, especially if you've got long-term trusts that are in place, for children or for grandchildren. And then you also just want to make sure that you don't pick an executor who doesn't get along with the beneficiaries in your will. So it seems pretty basic, but having clashing personalities, that does not make for a smooth estate administration. And I'm sure many of my estate litigation lawyers can attest to that fact. It definitely makes their lives better, but not a great idea for family harmony or for an effective administration of an estate.
Thank you. Yeah, Sheek, did you have anything to add?
Yeah, I was just going to share a personal story about my wills, mine and my wife's wills and power of attorney. We got married in '87. We had the wills drawn up back then. We updated them in 2006 because our children were still under 18 and we needed guardianship if something happened because we were traveling a lot. Then we just got the final will done yesterday with the new appointments and what we want to do now. And if I had kept the old ones, if something happened to us, it would have been helter-skelter. We had guardianship. We didn't have appointed an executor that we knew. We didn't appoint the powers of attorney to the people we wanted to. So it would have been a total mess if something happened to us. So yes, Susanne is right. You should review it on an ongoing basis. And Sheean said, we remind our clients regularly to review it and see where we are. Most people don't do anything because they feel they're in good health. They don't have to worry about it. But when it happens, you don't have time to fix it. And that's the issue. So yes, review with your advisors or your financial advisors or your accountant on an ongoing basis. If nothing else, at least you'll be able to update things that you forgot or you thought you had or you hadn't. Go ahead.
It's funny, Sheek said that, he basically just said that it took him 15 years to update his will. That's because he was helping everyone else, just so everyone knows. So I guess one other question, this is pretty common. A lot of people die without wills. What are some of those repercussions? I know, like, when we get, new clients coming on board, some of them just tell us, like, well, we don't have a will. We have it written down on a napkin. I'm like, oh, well, I guess we need to, meet with Susanne. So Susanne, why don't you tell us a little bit more about what happens?
Yeah, absolutely. So again, yes, it's extremely common to not have a will. That means it's not a good thing, but only about half of Canadians actually do have valid wills in place. And I would say even fewer of those have updated wills in place. So, it is common, but there are some real repercussions to not having a will in place. The first thing I do want to clear up is a common misconception that clients have. So even if you do not have a will, it doesn't mean that the government gets your assets. The only time that the government hangs on to your assets is if you do not have any family members who are alive. So that's point number one. But there are still some very valid reasons as to why you want a will. And then I have to then divide that again into distinguishing between who gets your assets and who gets to control your assets as executor. So very different issues, but let's just start with who gets your assets if you don't have a will. We have laws in Ontario that are very clear. They're called intestacy laws. You cannot deviate from them if there is no will. What it means is that, so if you die with a spouse and children, that's where your assets go in certain proportion. If you don't have spouse and children, you have grandchildren, it goes to grandchildren. If you don't have any descendants, then it goes to your next closest surviving relatives, like your parents, siblings, nieces and nephews, cousins. Without a will, though, the problem is that you do not get to decide how those family members get those assets. So if you die without spouse and descendants, say your parents get your estate, that's it. Your siblings, your nieces and nephews, they don't get anything. If your parents are alive, they get it. So maybe that's fine, but you know, we've seen situations where maybe you have a niece or a nephew that might need that money, or they might be better able to use that money because they're going to university or they're starting a business.
Correct.
Maybe it makes more sense to leave that money to them than to your 82-year-old mother who, you know, again, has sufficient assets for herself. So not having a will means you lose that ability to choose. So that's a very valid reason why you would want to have a will in place. Again, relating back to the control aspect of it. Another really important point that I want to make is for anybody who has minor children and does not have a will, it does create additional complications. The reason is that minors can hold assets in their name, but they do not have the power to deal with those assets. The other complicating factor is that most people assume that, you know, the parents can do that on the child's behalf. That is not the case in Ontario. So you do not automatically have the right to deal with an asset that belongs to your minor child. So either that parent has to go to the court to be formally appointed as guardian of property, or you need to have a will that provides that parent the power to deal with that asset. So if you don't have a will, minor children inherit. What it means actually is this is a situation where the government, provincial government, Office of the Children's Lawyer, does actually hang on to those assets until the children are 18 in Ontario, and then just releases it to them at that point in time. So from a practical perspective, if you think about what you were like at 18, may not have been the best idea to suddenly be getting a large check. The other more serious complication is that until that age, it's not easy to get assets released for the care of the children. So again, having a will protects against that. So those are some very important points to keep in mind, especially for clients who have children under the age of 18, or again, if you want to control how some of your assets go so that it doesn't just default automatically to certain family members. The other thing that I just want to address before we move to the next question is people have a hard time distinguishing between where assets go and who has the power to control how to transfer those assets. So we just talked about the executor appointment. That's really important. If you have an executor appointment in the will, it's the executor who carries out those wishes. If you don't have a will, you don't have an executor. You don't have anyone who automatically can step into that role. That's what you need that will for. So what I commonly see is with respect to spouses, they just assume that because they're married, they can automatically deal with the estate of a deceased spouse. And that's not the case unless you're already a joint owner of that asset. So what it means is that that individual has to take an extra step to go to court in order to be afforded that right. So this is an extra step and cost that could be avoided if you actually had a will that would appoint an executor. So in a nutshell, those are some of the common issues that we see when someone dies without having a will in place.
Wow.
Thanks, Suzanne. We actually just got a question from Anonymous. Besides a lawyer, who else can notarize your will?
So that's an interesting question in terms of notarization, because that has a different connotation depending on where you live. So in Ontario, there's no requirement that a notary prepare your will. Okay, so there's a couple of different ways that you can have a will in Ontario. You can either have a holograph will, which is a will that you write entirely in your own handwriting, doesn't require witnesses, or you can have a will in front of witnesses. So typed up will where you have two witnesses that sign in your presence and that watch you sign the will. It doesn't necessarily have to be a lawyer who is one of the witnesses in Ontario. We always say it's a good idea to have a lawyer be involved in the preparation of the will for reasons that we've discussed. They can help you make sure that things are drafted properly, but there's no requirement that a lawyer be involved in preparing a will in Ontario. A little bit different in a province like Quebec, where we have something called notarial wills, where it's actually a notary that prepares that and then registers that. We don't have that system in Ontario.
Thanks, Suzanne. I think that was a perfect answer to that question. Well, I know this is going to be maybe a long answer for this next and final question that I have. So hopefully we'll be done this webinar in about 5 to 10 minutes. But I think we are going to talk about the one thing that I think a lot of people don't realize is when you die, there's a possibility a lot of your money goes to the government. So let's talk about death taxes or estate taxes and how taxes affect you and your family at death.
Right. Yeah, no, you're right. This is definitely something that could have its own webinar. So I'll try to hit some of the highlights on income taxes. So the key thing to remember here is that CRA considers your death a taxable event. So CRA thinks that because of your death, you have sold everything immediately before your death at fair market value. So this is what we call a deemed disposition at death. It means that the assets are still in your name. They're still in the name of the estate. They haven't gone anywhere, but CRA will tax it as if it's a sale. Then, depending on the asset and depending on who your beneficiaries are, the estate will pay those taxes before any assets can be distributed. So when I talk about depending on who the beneficiary is, it's really important to understand that if you are married or common law, if you leave an asset to that surviving spouse, you can actually defer when that taxable event happens. So instead of having to pay the tax, in your final tax return at death, if you leave it to a spouse, you can actually defer. You roll over the asset to the spouse, and the spouse doesn't pay until he or she sells the asset or until he or she dies. So that's a really important concept when we talk about taxes, especially when it comes to married or common law spouses. The other thing that's important is that deferral, it's usually not available to anyone other than spouses. So usually when we get down to the surviving spouse who's planning his or her estate, that deferral is usually not available to kids. So that's an important thing to keep in mind. Where most clients that I see get dinged on taxes is on their RSPs or their RIFs, especially when there is not a spouse as the beneficiary. The reason for that is that, when you contribute to your RSP, you get a tax refund. When you start withdrawing from the RIF, you pay taxes on the withdrawal as you go along. What death does is it makes CRA treat what is in that RIF as one big withdrawal, and that gets included in your income. So on a practical level, what that means is that you're usually losing about half of whatever is in your RSP or your RIF to tax at death. So let's say you've got $300,000 in your RSP at death. You don't have a spouse that you can designate as a beneficiary. Really, after tax, what you have is about $150,000 plus or minus, depending on what the tax rate is. So standard rule of thumb, RSP taxed quite heavily. The other thing that I want to briefly just point out with respect to taxes that affect a lot of your standard estates is capital gains tax on cottages and secondary properties or income properties, and long-term stock investments. So the other thing that CRA will tax is capital gains. So that is the increase in value from when you bought an asset to the time that you sell an asset. So in Canada, what happens is 1/2 of the increase is taxed, and then that's taxed at whatever your marginal rate is at death. So a really quick rule of thumb, if you're trying to do a quick and dirty calculation, is that you're going to lose about 25% of that gain to tax. So let's say you have a cottage, you bought it for $50,000, you didn't really do many repairs to it. Now it's worth $250,000 at your death. So you have $200,000 in gain. Half of that, so $100,000, is taxable. So we're looking at about a $50,000 tax, right? 25% of the gain is taxed. So again, it does get a bit more complicated than that, but that's essentially how that capital gains tax works. The other thing that I see in a number of clients is they will buy and hold stocks for a long period of time. So this is really common for things like bank stocks that were purchased decades ago. You know, they're paying out dividends, which is lovely, but they've also increased in value quite significantly over time. So it's just important to understand that if you buy and hold for a long period of time, there's also capital gains tax that will be levied on that at your death. To end that though on a positive note, because that's a lot of tax that's being taken out of your estate, is that one really important exemption that applies to most clients is what's called the principal residence exemption. So this will be, I think, some relief to a lot of your clients, especially in the GTA, where homes have, you know, gone up in value quite significantly. CRA actually does allow you to exempt the entire capital gain of one principal residence. So it's not a deferral like the rollover to the spouse, it's an actual exemption, which means that you can sell your home without having to pay any of that capital gains tax if it's your principal residence. Or on your death, it means that CRA will not ask for the capital gains tax for that because it's exempted under the principal residence exemption. So that's one little bit of relief that CRA does provide.
Thanks, Suzanne. Yeah, that's I'm just waiting for it to pan over. There you go. It seems like no matter what, you're going to be paying some tax. Hopefully you have yourself all set up properly and you've talked to Suzanne and us and everything's going to be honky-dory. That's why we do these things. But yeah, it seems like the government definitely will take their share if they have the opportunity. So I don't think people have realized that. They're like, oh, I have this much money, and they think their children are going to get it. So well, I'm going to leave it open for a couple more seconds here for any last questions. And if there's not any, we are going to shut this down. I'm just going to wait a couple seconds here. Don't see anything just yet. Again, if you want to get in contact with us, our website is patelwealth.ca. You can book a meeting right on there with us, and it'll go right into our calendar. You can send us an email, sheean.patel@nbc.ca or shik.patel@nbc.ca. And if you want to call us, 905-849-3549 or 905-849-3551, and we can set something up. I hope all of you found this really a great topic and you learned something. And hopefully we see you again soon. All right, thank you, everyone. And if Nick just pans over to everyone, everyone can give a little wave goodbye.
Thanks.
All right, bye-bye. Thank you very much.
All right.
Thank you.
Bye-bye.